Good afternoon. Thank you to everyone for being here and for those that are joining us online or in the Harrison building for our grand rounds on nuclear verdicts, Georgia's litigation crisis. This is a topic that is critical to not only our physician workforce, but to the state as a whole. For those that don't know, and I hope I'm not stealing any thunder from our presenters, but Georgia was named the #1 judicial hellhole in the country in terms of nuclear verdicts. And that is causing issues for our physician workforce and for the practice of medicine, and more importantly, for our patients in this state because of the impact of this, not only on business, but on our ability to deliver health care. So today we have two presenters from the Medical Association of Georgia, Jeremy Bonfini, who is the Executive Director and CEO of the Medical Association of Georgia, and Brent Walker, who is the General Counsel for the Medical Association of Georgia. I'm going to make just a couple of introductory comments and then turn it over to Jeremy for a little bit of an update from the Medical Association of Georgia. For those that don't know, WellStar pays for the physician medical staff within our organization for the medical staff members to be members of the Medical Association of Georgia, as well as for all of the residents and medical students. So we're very pleased that for this year, for the first time, the residents and medical students are being included in that. So most importantly, almost everyone that is attending this presentation, either in person or virtually, is a Medical Association of Georgia member. I'm going to be distributing information concerning the Medical Association of Georgia, make certain that you guys are aware of upcoming events so that we can get our members and our voice heard at the state legislature. The best way to get the attention of the state legislature is when faces show up, that means votes, and that means that they should be paying attention. So I would just encourage you to become engaged. We're going to be talking about some of the upcoming events that we would like for you to be involved in, and we'll highlight those later in the presentation. So without further ado, I'll turn it over to Jeremy Bonfini. Let's make Jeremy welcome.
Dr. Cole, thank you for the kind welcome to WellStar MCG Health and the Medical College of Georgia. With nearly 200 years of shaping the future of medicine in Georgia, this flagship medical school also created the Medical Association of Georgia, which we are happy to mark its 175th anniversary this year. And while we celebrate the past 2 centuries of medical achievement in Georgia, we are increasingly concerned with the changes of the past few years. A healthcare workforce shortage, which you all feel every day, has been bundled with ever-increasing barriers to care for the patients and is challenging our physicians. To shift the healthcare system away from paperwork to patient care, we must unify the physicians of Georgia. And that is why I'm here to thank you for continuing to grow your membership in MAG and ask you to advocate for your profession and for your patients. Interestingly enough, the patient-physician relationship is ensconced in the AMA Medical Code of Ethics with some very weighty words that I'm sure that you all are familiar with. That physicians have an ethical responsibility to place patients' welfare above the physician's own self-interest or obligations to others, to use sound medical judgment on patients' behalf and advocate for their patients' welfare. Very short statement within the Code of Ethics, but a very weighted one that places a burden upon our physicians to place the care of their patients above all other priorities. And that is increasingly difficult in today's environment. And it's why I challenge you to advocate, both here in the state capitol in Atlanta of Georgia and in the national capitol in Washington, D.C. You can see our largest Physicians Day at the Capitol, and you can see some very familiar faces in the center of our Physicians' Day at the Capitol here in February. And I want to talk to you about the achievements that your representatives to Physicians' Day at the Capitol and your representatives from the Medical Association of Georgia have achieved in Washington, D.C. In our nation's capital, prior authorization reform has been enacted. By 2027, health plans regulated by CMS will be required to have the electronic prior authorization embedded in the physician's EMR. We understand your frustrations created by spending hours on the phone, playing phone tag just to get approval for a treatment that is the right thing to do for your patient. In addition to the transparency and the requirement that prior authorizations be processed in the EMR, there will be requirements for plans to respond in a timely fashion, preferably within 24 hours. And prior authorization decisions will be reported both to the public and regulators in Washington, D.C. This incredible accomplishment came about through the advocacy of physicians, much like the ones you see in this photo, both in the state capitol and in Washington, D.C. We ask you to help us to continue to grow that advocacy because there are incredible challenges. Just on the prior authorization issue alone, 2 years ago when I was in Washington, D.C. with the MAG delegation, the federal government said, wait, if physicians aren't processing prior authorizations, they're going to be treating patients, and that's going to increase the cost of care. And that will cost the government billions of dollars. That was the logic that we had to overcome to get to a point where we can streamline the paperwork so that you can care for patients the way that you've been trained and the way that brings true joy to the practice of medicine. Also, here in Georgia, we have passed HB 455 to establish a physician safe haven program that creates legal protections for physicians and an innovative wellness program. This bill in Georgia Code establishes legal protections for physicians which addresses issues related to burnout. All participants of Safe Haven are immune from reporting unless they are a danger to themselves or others. Consultations under Safe Haven are also considered privileged communications and do not propose a risk to physicians' medical license except under extraordinary circumstances. This Safe Haven legislation was passed almost unanimously out of both the House and the Senate and currently sits on Governor Kemp's desk. Once the Safe Haven bill is signed by Governor Kemp, and we have no reason to believe that it won't be, this will usher in a new era to tackle the early stage stressors that physicians and your colleagues face on a day-to-day basis. And we look forward to telling you much more about Safe Haven and the accomplishment that we brought into effect through your advocacy at the state capitol. Some key dates, how MAG works and how you can contribute and be engaged. We have MAG set up as a democracy, maybe with a little d, but it is still a democracy. Physicians across the country in organized medicine have a role for each physician to have their voice heard as a member and to influence the policy that is set by the Medical Association of Georgia at our House of Delegates from October 18th to the 20th this year in Savannah. There will be a medical student and a resident poster competition, and MCG has been very well represented there. We invite you to become part of the policymaking process. Following the House of Delegates, and the delegates have ratified our policy positions, this informs legislation that will be introduced by key physician advocates who are elected officials in the state legislature, one of whom is from here in Augusta, Mark Newton, who's a state representative. So the work that you do with the House of Delegates translates into legislation offered by our advocates for the patient-physician relationship that hopefully translates into the law of the land. Because there is one key item to recall, that it is not the chief resident, it is not the chief medical officer, it's not the CEO of the hospital who determines how medicine is practiced in the state of Georgia. It is the state legislature. Again, it is the state legislature that meets for 40 days in the first half of the year from January through March that determines the practice of medicine. And that is the same throughout the country. In Oregon, naturopaths would like to conduct surgery, and they're asking their state legislature to allow them to conduct surgery and to write Schedule II prescriptions. The practice of medicine is under assault from many different angles, and it's only through your advocacy that those elected officials here in Georgia hear from you on the front lines, caring for the patients every day. It all starts with our House of Delegates. Our board of directors are also an integral part to the governance of MAG. They are the fiduciary body of MAG. They are also the interim body that governs policy between the House of Delegates meetings. The executive committee is composed of our officers. There are standing special committees and task forces, county medical societies, and district medical societies, all of which you are welcome and encouraged to participate in. Coming right up, speaking of advocacy, following each legislative session, MAG hosts a legislative education seminar with some of the key decision makers in Georgia. This will be held May 17th through the 19th at Brasstown Valley Resort. You are all encouraged to attend. Dr. Perard will be circulating a QR code so that you can link to the page and get more detail about registration for a legislative seminar. The House of Delegates, as I mentioned, in Savannah, October 18th through the 24th, October 18th through the 20th of 2024. And of course, MAG benefits. We do have membership benefits of we hope that you avail yourselves, including CME, your state required CME, other required CMEs that are coming down the path. There will be death certificate CME because guidelines around death certificates are changing. And you need this important regulatory information so that you can carry out your jobs here in caring for patients and providing the very best care that I know that you do every day. Thank you so much for your time and your attention. We're always available to you, jbonfini@mag.org, and Brent Walker will give you his contact information, and we'll tee up for you the next big challenge ahead that Dr. Kuhl mentioned. Nuclear verdicts. We have a malpractice liability situation that's out of control here in Georgia. It will define the future state of medical liability and practice, and Brent will tell you a great deal more about it. Bottom line, we need you to be active. We need you to be engaged. Dr. Kuhl's an incredible advocate and well-respected leader across the state of Georgia. Thank you so much for making this happen and bringing this about, and thank you for your time and attention.
Thank you, Jeremy. And we're going to move into the presentation. Brent, I'll tell you, I've heard Brent speak many times, and he is not only a great lawyer, a really smart guy, but more importantly, he's a Georgia Bulldog. So Brent, welcome, and thank you. We look forward to your presentation.
Hello? Okay. Hey, thank you, Dr. Kuhl, for that introduction, and thank you, Jeremy, for your words. And thank you, everyone, for attending here in person and following along remotely with us. It really is a pleasure to be here with you today. It's one of the important parts of our mission is to reach out across the state to our physicians, our students, and residents, and really work on the issues that impact your practice every day. And I'm very proud to be a part of this organization. I've been the general counsel for almost a year now and been thrown directly into the fire. Before that, I was a practicing attorney for nearly 17 years. I had my own private practice for about the last decade in Sandy Springs. And over that time, I was a trial lawyer specializing in complex litigation and plaintiff's medical malpractice for the first part of my career. Then I saw the light and moved on to medical liability defense, and then opened my own firm as outside general counsel with a focus on a lot of healthcare clients, moving through helping them navigate a complex and ever-growing regulatory environment. When I had the opportunity to join the Medical Association, I really jumped at it. The mission of this organization resonated with me. I've been in and around healthcare for the last 20 years, my own brother, who practices locally and is a graduate of MCG. And if you know him, you'll know who he is by seeing me almost immediately. Has been a practicing physician here for almost 18 years. I believe very strongly in the mission that has been set before us here. And as Jeremy mentioned, this is our 175th year. It's our 175th year of being the leading organization advocating on behalf of physicians and their patients across this state. And throughout that time, we've seen one crisis after another. Since 1849, this organization and our physicians have weathered wars, occupations, financial crises, more than one pandemic, and a slew of medical liability crises, stretching all the way back to the 1840s when American courts first started to really recognize an action for medical malpractice. Every generation of physicians has dealt with this. The nature of these crises run in a cycle, and what causes them is oftentimes different. And it really follows the money, it follows the system. Something gets out of balance, and it's up to us to stand up and work to advocate to bring the system back into balance. Since the 1980s, we've had 3 or 4 of these crises. 20 years ago, the Medical Association of Georgia led the way in medical liability and tort reform and passed a very successful package of legislation that had a distinct impact on the practice of medicine in the state. Unfortunately, over the last 20 years, the progress we made has been chipped away at. The scales of justice are once again imbalanced, and the practice of medicine in all industries in this state are really under siege. And that's what I'm here to talk about today, is really the tort environment and the civil liability environment generally, but specifically how it impacts the practice of medicine in our state and why we're in a medical liability crisis right now, and also what we can do to improve it. As we mentioned, nuclear verdicts. That's one of our leading indicators of just how bad things are getting. As Dr. Kuhl mentioned, Georgia has been named the #1 judicial hellhole, not just for 22 and 23, but again for 2023 and 2024. That dubious distinction is awarded by an organization called the Americans for Tort Reform. And since 1986, they've been following a variety of metrics across all 50 states and territories, looking at what causes civil liability crises, what creates a judicial hellhole. The primary thing that they look at is what's called nuclear verdicts. And those are verdicts handed down by a jury of $10 million or more. And unfortunately, the state of Georgia has been ground zero in the nation for these verdicts for the last 8 years. And an outsized number of them have impacted the practice of medicine. And this is really across all industries. And it has a distinct economic impact. When we do the calculations, it costs somewhere between $1,200 and $1,300 per Georgian in lost opportunity cost, in increased insurance costs, and a variety of other factors. It costs us almost 125,000 jobs and $13 billion in economic output. And the money that's won in these lawsuits is reinvested by the personal injury lawyers right back into the system, right back into protecting the economic benefits that they and their clients derive from this system to our detriment. And they spend upwards of $85 million a year on advertising just across this state. And that has an impact on medicine specifically. Of the nearly $4 billion in verdicts over the last 5 years that were $10 million and more, $790 million have impacted healthcare across the board. That's 28 verdicts in this state since 2016 in excess of $10 million. That's impacting our hospitals, our allied health professionals, our physicians, and most importantly, it's impacting our patients. It has a very distinct downstream cost and impact that makes our lives more difficult. And if we look across the country, we're one of very few states that has an excess of these healthcare liability verdicts. So what we want to talk about today is helping you understand this crisis. It's a very complex issue that's facing us when it comes to civil liability reform and medical liability in this state. A lot of different factors impact it, and none of this really exists in a vacuum. But when we look at it generally, when you walk away, I hope that you have a greater understanding of what's going on, what the indicators are of why we're in a crisis after the last 20 years. What are the impacts and causes of that crisis, and how we, as an organization in the Medical Association of Georgia, respond to it, how your institutions can respond to this crisis, and how you, on a day-to-day basis as a practicing physician in this state, can work to improve the climate for everyone, including your patients. Before I dive too deeply in, I wanted to give one recent example. I think generally in medicine, we're aware that not every specialty is the same when it comes to risk and liability. There are several that are really high risk, whether that's surgery or psychiatry or obstetrics and gynecology, because of the nature of the practice, because of the way the patients present and the catastrophic potential for things to go wrong. But because of these nuclear verdicts and the downstream impact, it's affecting not just high risk specialties, but all specialties across the state of Georgia. Just last October, a Henry County jury awarded a $16.4 million verdict against an urgent care physician in Henry County. They said that the physician and the physician's practice were liable for $8.36 million of that. When we look at what happened in this case, a young gentleman came into this urgent care. He had just moved, he was about 27 years old, and suffering from anxiety and depression and loss of sleep, very typical things. The physician, in a very typical interaction, gave an evaluation, followed the standard of care as he understood it and was accepted across almost all 50 states, and gave a prescription of Xanax and citalopram, Xanax as needed, citalopram for 30 days, almost 4 weeks, and to come back. Unfortunately, less than 4 weeks later, that patient committed suicide in September of 2017. And the family of that patient from Florida brought this suit against this practitioner in Henry County. And that really is devastating, because that's not something that we have seen in the past. We've seen this liability creep across the spectrum and impact a lot of different practice areas that were typically low risk. When they got in front of the jury last October, the jury found that, the standard of care was that was breached was that the physician failed to perform a mental status examination and failed to set a specific follow-up appointment, which is hard to believe how that could be a violation of the standard of care. Follow-up appointments were set when we review these records. The impact, the drug prescriptions, appropriate notices were given. The pharmacies had advised on the new prescriptions, but none of that really seemed to matter when it finally got into the hands of the jury. And when we look at the package insert for citalopram, we know that somebody that's around 27 years old actually has a reduced chance of suicidal ideation within the first 4 weeks of taking that particular drug. And so what we do as an organization is take a look at cases like these and try to understand what happened. What is the anatomy of care and the legal process that led to this really untenable result? Now, they haven't always collected on these verdicts. That 28 list, which this is included on there, those are just verdicts. That's not $790 million that has been collected. That's $790 million to which a handful of plaintiffs, about 28 or 29, and their attorneys are entitled to collect. A lot of these cases go up on appeal, and this one in particular is getting ready to go up on appeal after I checked this past week for a variety of reasons. But it's important to understand that these verdicts alone have an impact, because it's not just the amount of money paid, it's the amount of stress that it causes, it's the downstream costs that it impacts the practice of medicine. It's all of these things that are being used against physicians in this state and healthcare writ large. So let's go back to some of the indications about why we're in a crisis right now. As I noted, there's 29 verdicts, that's $790 million. And what happens is when these verdicts are awarded, the lawyers who got them use them first and foremost as an advertising tool. It drives more business their way. Second, what they do is they take these verdicts and they go into the counties where they got them, and they use them as leverage to obtain higher settlements in similar cases, which is really, really tragic. Because they'll go in to, say, Macon-Bibb County, and they'll say, well, here's a birth injury case. The jury just handed down $15 million. Do you really want to take that risk? Give me more money. And what we've seen as a result of that is that the average settlement value of a medical liability claim in Georgia has steadily crept up over the last 30 years. Today, the average settlement value is about $615,000 per medical liability claim, well above the national average of about $380,000 to $400,000. That's indicative of a crisis in this state. When we look at this chart, we see that the more than 60% of the settlements, and this is paid settlements, this is National Practitioner Data Bank information that we've pulled. These are amounts that have actually been paid in medical liability claims. Over 60% of the claims are in excess of $250,000. The last time we faced a crisis in 2003 to 2005, that number was about 38 to 40% of settlements of medical liability claims and verdicts were in excess of $250,000. That's really one of our key indicators that there's a massive problem happening when it comes to medical liability in this state. Now, when personal injury lawyers see this, they see a gold rush. When they look at it, they say, well, I could do 100 car wrecks for $15,000 or $20,000 a year, average settlement value, or I could do 3 to 5 medical liability cases and make the same amount of money. So the other downstream impact that we see is that a lot of lawyers that don't typically practice medical liability have started to jump into the field. And so it's not just the dozen or so firms in the metro area, 30 or so across the state that do this on a regular basis. It's lawyers that are coming from other specialties, and that drives up costs when they don't understand how the system works, how the rules work, how medicine works. When they don't understand that a bad outcome is not indicative of a failure of the standard of care, but they are going to try. And what happens, and we've seen a rise in these sort of frivolous claims brought by inexperienced lawyers over the last year, that may not result. The claim is probably defensible. There's a good chance it'll get dismissed at some point during the process. And even though the claim is defensible, you still have to spend the money to get it. You still have to report it to your carriers. You still have to get assigned counsel. They still have to negotiate, and that drives up the costs across the board. When we look at the amount of claims paid, we see that medical liability reform can be effective. If we take, leading up to the 2005 reforms, we saw an alarming rise in the number of medical liability payments across the state. In the 10 years before 2005, physicians alone paid out almost $1.7 billion in medical liability claims in the state of Georgia. And we saw that just rising and rising. And after we enacted tort reform in 2005, we saw a steady decline until around 2010 and 2011, when the Georgia Supreme Court overturned a key aspect of the tort reform law. What we've also seen is a number of other factors that we'll discuss later that have contributed to the rise. And if there was one silver lining in the pandemic, it's the fact that the courts were closed, so claims couldn't be brought. And it's unfortunate, but it's very true. But what we've seen in the aftermath of the pandemic is that claims are on the rise again. Just last year, it was almost $150 million in claims paid just by Georgia physicians. In the last 10 years, this is how much Georgia physicians, MDs and DOs have paid in medical liability claims. That's settlements and verdicts. $1,507,480,000. In that same time frame, 12 Georgia hospitals closed. That amount of money could very well have saved at least 2/3 of those hospitals. That amount of money could have enabled access to care for hundreds of thousands of Georgians. Instead, it went into the pockets of about 2,500 plaintiffs that settled these claims versus almost 12 million Georgians today. Instead, at least 1/3 of that went into the pockets of their lawyers. Instead of going into the system in improving the quality of life and the health and well-being of all Georgians, this bought Mercedes and jets and yachts. This is a major problem. And the only reason that number isn't higher, like I said, is because we had the pandemic, which closed the courts for about 18 months and leveled off the number of claims that were able to be brought. This has a distinct impact on medicine in Georgia. Speaking of impacts, when we look at that number in those charts, the first impact that physicians feel really, besides the increase in the number of claims, is the cost of practicing medicine, specifically the amount of premium that you have to pay for malpractice liability coverage. It has been steadily increasing over the last 5 years in the state of Georgia. We see high-risk specialties, particularly obstetrics, having to pay north of $70,000 to get a $1 million, $3 million premium. We see other high-risk specialties like emergency medicine and psychiatry in the same boat, and I have spoken to obstetricians that do labor and delivery that have to pay now as much as $100,000 to $120,000 to obtain just a $1 million, $3 million policy to cover themselves and try to mitigate the risks that they're facing. That situation truly is untenable. Georgia, when the American Medical Association tracks this, We're one of only 6 states that have had a large premium increase for the last 3 years in a row. 2023, we've seen a massive increase, and we're also seeing indications that that's going to be the same for 2024. For the last 5 years, medical liability premiums have been increasing. And that cost is being borne by our physicians, but in particular, it's being borne by the patients because that increases the cost of care. It also affects our ability to recruit and retain physicians across the state. When we look at it, the most recent data available from the Board of Healthcare Workforce that's run by the state of Georgia, we had about 230 physicians per 100,000 residents of the state of Georgia. That still ranked us about 40th nationally in access to care. Out of 25,000 or so resident active practicing physicians in the state, that is still woefully low. We need to be at about 300 per 100,000. So we probably need another 12,000 physicians just to cover all of the health care that is being delivered in this state. But it impacts specific specialties distinctly. We've seen a decrease in the number of general surgeons, OBGYNs, and in particular psychiatrists over the last several years that's leading to a drop not just in the cost of care, but the access to care for all Georgians. When we look, nearly half of Georgia's counties don't have access to an OB, a general surgeon, or a psychiatrist, and almost half don't have access to a practicing emergency medicine physician. This is also a really alarming result of these outsized verdicts, is the fact that people lack care. It also encourages the practice of defensive medicine. When the threat of litigation is hanging over the head of a physician, they may order extra tests to cover themselves. That drives up costs across the board. Like I said, the increase in the amount of insurance premiums is passed along most often to the patients. And also we see that it impacts not just our ability to recruit, but also to retain physicians. When we look at that 25,000 physician number, 1/3 of our physicians are at or near retirement age today. In the next 3 to 5 years, that's going to be more like 40 to 45%. And when we look, that has an impact. 142 of Georgia's counties are health professional shortage areas. That's not just physicians, that's mid-levels, that's nurses. That impacts our most vulnerable low-income citizens. And it impacts economic development across this state. When we think about that, we have a lot of really good infrastructure. We're the #1 state to do business. We can't be the #1 judicial hellhole in the #1 state at the same time for much longer. And when we look at it, a lot of the economic growth that's happening in our state is happening outside of metropolitan areas, in particular Atlanta, Savannah, and Macon. It's rural Georgia. When you drive down I-16 or I-20 and you see the warehouses that are being built, you see the factories, there's a lot of growth, and that's attributable to a favorable business environment. It's good infrastructure, it's good transportation, it's good schools in a lot of areas. But if we don't have health care, we're going to see a direct impact, because without our physicians, we can't get people back to work. We can't treat them. Costs go up, employment goes down, and companies start to leave the state for more favorable climates. So this is really an important issue, not just for physicians, but for all of us. And not just when we talk about retirement age, Georgia's projected, even discounting the medical liability crisis, just looking at the natural progression, we're going to be short about 8,000 doctors in the next 6 years. Primary care alone is going to be short almost 2,100 physicians. The medical liability crisis is accelerating that, not just in our ability to recruit physicians, but in our ability to retain physicians. What I've seen going across this state and speaking to physicians is that when a claim is filed or presented against a physician who's nearing retirement, it's too much. The stress of it is more than they can handle, and they elect to retire early. So I think that these numbers are going to be dramatically different over the next 6 years. We're going to see an incredible decrease. Now, there are certain things that are being done to address this. There's talk of a new medical school in Athens, which is laudable, but it'll be 4 years before we graduate somebody from that school. It'll be another 3 to 5 years before they finish their residency and start active practice. That's well into the next decade before we have more physicians to cover this shortage. We're also working very hard to increase graduate medical education slots in this state, but we aren't increasing them fast enough. All of this together represents a crisis. And many of the solutions that we're enacting now to address this crisis aren't really sufficient in the very near term to address it. Let's look at a few of the causes of this crisis. We've seen some of the indications. It's not an exhaustive list, but it gives you a high-level understanding. The environment in Georgia was pretty favorable starting in 2005, but unfortunately the Georgia Supreme Court, in a decision called Nesselhut versus Atlanta Oculoplastic Surgery, overturned a key provision of that tort reform package, and that was the cap on non-economic damages. They said that that was unconstitutional, and what non-economic damages are is anything that isn't easily quantifiable, like lost wages or missed time from work or property damage. It really primarily consists of pain and suffering damages. And what we've seen is that that's a really subjective metric. It's really difficult for 12 people in a jury box to assign a monetary value to someone's pain and suffering, right? We all experience pain and suffering very differently, but with the cap on non-economic damages being overturned, juries were able to really run wild with this. They were able to express their outrage in numerical value and start handing down these massive verdicts in excess of $10 million. Even $2 to $8 million is on the rise in the state of Georgia. About a third of the cases are that high. It's really impacting what's happening here. And one of the issues is that the trial bar and the plaintiff's personal injury attorneys really leaned into this because Georgia, under the evidence code, is one of about 4 states that allow attorneys to directly argue pain and suffering to a jury. They can sit up there and they can go on and on about how bad it hurt, how much sleep they lost, how disfigured they are, right? And that leads the jury to an emotional outrage. And it leads them and inspires them to hand down, when they have this pain and suffering tool, outsized verdicts. When we review the jury verdict forms from a lot of these cases, what we see is there'll be $200,000 or $300,000 in lost wages, $100,000 in medical bills, and then $6 million in pain and suffering. And what's happening is that's the jury expressing their outrage. It's not a rational expression of making that person whole again, that person. They're allowed to express their outrage, but no one stops to consider that a typical physician couldn't pay off a $30 million verdict in 10 lifetimes of working. There's no substantial justice being done by that. However, the Supreme Court, in all of their wisdom in 2010, decided that, well, it's unconstitutional to cap damages, that invades the right to trial by jury in this state. And speaking of juries, there was another instance and one key factor that led to the rise in these verdicts in 2011. And this is an example of trying to solve one problem and creating a few more down the line. The 2011 Jury Composition Reform Act passed. What was happening is there weren't enough people serving on juries in the state of Georgia to keep the caseload moving. There's about 60 to 65,000 civil cases filed in the state of Georgia every year. A typical judge in a metro area will have anywhere from 1,000 to 1,800 cases pending on their docket before them, and they need to get them cleared, and they needed people serving on the jury. Before 2011, juries consisted of individuals that were registered to vote in the county. After this act, that pool was expanded to include people that had had a driver's license in the county for 2 years. And it had a dramatic result on the size of the verdicts that were being handed down. The defense lawyers did a study in 2022, and they looked specifically at wrongful death verdicts across the state. In the 5 years before the Jury Reform Act, the average verdict handed down by juries was about $1.6 million, and the mean was close to $4.2 million. And what they were evaluating in wrongful death was the value of the life of the individual that died. After the act, they examined another 52 or so jury verdicts across the state, and we saw a dramatic increase. The average value of the verdict went to $7.5 million, and the mean was $17,270,000. That is a huge increase across the board, which when we look at the 28 cases that are on that first slide, about 1/3 to 40% of those involve a death. Those cases that reach those high numbers involve death or catastrophic irreversible injuries that impact the quality of life of the patients. And they set them in front of a jury, and the jury sees that, and they express it. And it really needs to be curtailed. Now, the laws from 2005 are still in the books. In Georgia, the Medical Association is really taking a strong look at how to attack that, and we're working. I'll describe that when I talk about our judicial advocacy in a minute. But again, we see in 2010, the Nesselhut case, in 2011, jury reform, a dramatic increase in the size of claims paid and medical liability claims that have been brought in this state. And so we can find direct correlations to some of the things that have happened and understand where we really need to focus some of our efforts. So what we see is that the environment really does disproportionately favor plaintiffs and their attorneys. They'll focus on justice, they'll hand wave away a crisis, but we see key indicators that it's there because we've seen these crises arrive in the past, and we've seen the solutions come and go. The opposition has also done a very good job in the last 20 years. We talk about what's different now than 20 years ago, and there's a couple of really key things. The nature of the practice of medicine has changed. You know, in the next decade, we're going to see a dramatic change when it comes to technology and innovation in the healthcare space. But we also saw a change in strategies. What traditionally would happen when a medical liability claim was brought was called the deny and defend strategy. And generally, the claim would be denied and considered defensible, and they would focus on the amount of time and pressure that it would take to do a reasonable settlement. So that inspired rational thought when it came to taking these settlements. What happened is a claim could take 3 to 5 years to litigate. In the meantime, that plaintiff is sitting with the lights about to be shut off, mounting medical bills. They're inspired by time pressure and economic pressure to take reasonable settlements when it comes to this. But they adapted to it. They found a ready group of investors and venture capitalists that saw what was happening in the healthcare liability space and really in the civil justice space writ large, who were willing to invest in these cases. And that's third-party litigation funding. What happens is a plaintiff has a claim, a lawyer will give it a certain value, say $100,000 when it comes to settlement, and the plaintiff can go and get a loan against that. So they can get money to survive, which from a high level is laudable. The problem is it has developed. They took that money and they looked for more, and they found letters of protection and medical lien law, and they financed those. They went not just from consumers seeking $5,000 or $10,000 to get through the next 6 months, but they found commercial aspects of lending that they could leverage to make incredibly high returns on these cases. They started lending to firms, so that a firm, if a lawyer was able to get 8 to 10 of these high value cases signed up, they could either refer them out or they can go to one of these lenders and they can get a loan. I know of at least one lawyer that got 12 long-term care and nursing facility cases together and got almost $1 million loan that he was able to use and repaid it in about 180 days because of the force of the settlements. And that's happening across the board. And that really is a new key aspect of what's happening. And when we look at these companies really started to operate. They started in 2003 on the West Coast, but they came into Georgia around 2015, 16, and 17 is where we see the largest starting to come on board, and you probably see this quite a bit. What we also saw is the rise in medical liens, financing, and letters of protection, which I'll discuss more in just a moment. We mentioned that a little bit. It's a really expensive process. It's really not a loan. The Georgia Supreme Court took a look at it and determined that it's not a loan in a 2018 case, but it really looks like a speculative investment. And the interest rates are incredibly high on these loans. So what happens is the plaintiff gets a loan, say for $10,000 to meet their expenses, and the settlement comes in at $25,000, say 8 months later. Well, when they go to the lawyer and the lawyer says, hey, I've got a settlement. The client says, that's great. 25, that's just what you said. What about that loan? The interest rates are so high, sometimes 4% per month, that $10,000 is now about $18,000 that they have to pay back to this lending company. And what happens is the plaintiff, the client says, I can't take that. I won't have any money. And you need to go back and get more. And so what happens, particularly in medical liability cases, is it deters settlement. When they have this, they owe so much money that they come back and they say, well, you got $250,000. I can't take that, because these firms will lend up to $1 million, sometimes $2 to $5 million if the case is valued just right, and they're very good at valuing them. Their rate of return is something like 98% in 18 months, and they cycle it through, and it's symbiotic with the medical lien financing business. And so this is one that we look at very closely now because it's really come to fruition in the last 7 or 8 years. Interestingly, Georgia law says that contracts, maintenance and champerty is an old legal word. That's funding somebody else's lawsuit. That technically these are against public policy. It makes them void. The problem is that doesn't make them illegal. What void means is that if somebody sued or refused to pay the contract, the court would say this contract's void and they don't owe anything. These companies have gotten really good at getting in the middle and getting the lawyers on board and signing off on the settlements to where the client, when they sign the loan paperwork, also signs a letter of direction to the lawyer and says, you have to pay this back out of my settlement funds. And so the lawyer's caught in the middle. and has to pay it back. And then when the client says, I don't want to settle, they have to go back to the well. And so that's one of those factors that's driving up average settlement values of claims. Also in the medical lien space, medical liens are fairly complicated and they can be fairly lucrative for physicians. They mostly apply to patients that don't have insurance. But we've seen this move into other spaces where some nefarious actors, chiropractors, have started this in earnest, but we're finding a lot of medical practitioners are teaming up with plaintiffs' injury firms, and instead of having to go through the complicated process of filing a lien and giving all of the notice to perfect the lien, they get a letter of protection where the plaintiff's lawyer says, I agree to protect your interests. You don't have to worry with all the loan. I'll protect your interests and I'll pay you back. And we all know that what's billed to a patient is not what's collected, almost ever, when it comes to medical care and treatment. And it's very lucrative. If you wait on the insurance company reimbursement, you might get 20 or 30 cents on the dollar sometimes. But if you wait on the letter of protection and you can wait 3 to 5 years for the case to settle, what you see is that you'll get 70 or 80% of that money back. So there's a real economic incentive here, and these private equity companies have seen that, and so they took the money that they were making off of lawsuit lending and they went right in and started buying up medical liens. There's a lot of information that's still out there that we need to find. These companies are very good at staying below the radar. It's become an issue with the AMA and several other state medical societies where we examine the ethics of this, about whether or not using letters of protection and medical liens is in the best interest of the patients. If you're keeping the lien, typically you're not ethically compromised, but when we look at letters of protection and selling that lien, sometimes for a profit to a third party, there is a lot of questions there. It definitely drives up the cost of care. And one of the problems with the liens and the letters of protection when they're entered into is it can drive up excess treatment and costs. When the plaintiff says, no, I can't settle this case, the lawyer says, well, I need more information. I need more to drive up settlement value. So where do they go? They go back to the practitioner. Well, let me check you out. Let me order a test. Let me give you this product to try and help. Let me prescribe this medication. Let's drive up the cost so that we can get a higher settlement. Almost universally, this happens in this state on a daily basis. What we do need and what we work towards is improved regulation and oversight of these issues. It chips away at phantom damages, which I'll discuss a little bit later. And it's a chance to tie reimbursements to a reasonable basis, something like Medicare, Medicaid reimbursements, or other issues that we're still just beginning to examine. But again, when we look at the number of payouts, since 2010, we see the steady rise in the amount of payments that are being made. We're also seeing a rise in the amount of time that it takes to litigate a case. From about 15 years ago, it was 3 to 5 years. I've heard as much as 10 to 12 years now. And that really is an incredible stressor, not just on the costs of care that's being delivered across the state, but on our physicians. You're already stressed enough. Having a lawsuit hanging over your head for 7, 8, 9 years is also incredibly stressful because of the nature of litigation, because of having to show up in court, having to take time off to prepare for depositions, of not knowing what a jury might do, right? That really causes a lot more physician burnout, which is one of the reasons we focused very much on the safe haven law that Jeremy mentioned earlier, is an ability to get help for our physicians and to reduce the amount of burnout and the amount of stress that we're facing. When we look at the amount of time in litigation, AMA did a study, and the average physician with a 40-year practice spends about 4.2 years with an open medical liability claim pending against them, and we're seeing that number start to creep up. So how do we as an organization respond to this? We have a strategy that we've adopted over the last 18 months. It's basically 3 prongs. We're helping educate our physicians and other organizations about how to adapt to the current environment. It's one of the reasons I'm here speaking with you today, is to promote understanding and help discuss and promote discussion about what you can do now to protect yourself and what we can do in the future when it comes to legislation or judicial action. And to that point, we've increased our judicial advocacy. We are constantly looking, along with the AMA, who's pledged a great deal of support to us, to find cases against our physicians that are up on appeal so that we can get involved in these cases and help spread the word and educate not just the judges, but the juries and the patients about what's really going on, what the standard of care actually means. We're also increasing our legislative advocacy and engagement, not just with our Physicians Day, not just with our legislative seminars, but with our physicians. And with what we do at a grassroots level, because make no mistake, your voice as a physician within this state and in this community is very powerful and very compelling underneath the Gold Dome in Atlanta. We look at the current environment. What we really want to focus on educating our physicians on is how to mitigate risk, right? Risk mitigation occurs on a spectrum. A lot of times we just make the assumption that we've got liability insurance, we've got an LLC or a professional corporation, or we're under the umbrella of a hospital, that we're pretty well protected. But it needs to go further than that. When your typical 1 million, 3 million policy is standing against a $7, $8, $9 million claim, that makes you vulnerable personally. So we want to help people understand the liability insurance markets, understand different types of policies that may be available, understand other strategies, not just navigating insurance, but asset protection strategies that you can engage right now working with your financial professionals, your accountants, and your lawyers. Things like asset protection trusts that can be built to protect your assets and give you peace of mind in the face of the growing medical liability crisis that we are experiencing right now. Of course, MAG is uniquely positioned. We're building information, and most importantly, we're engaging and mobilizing our membership. And this time around, unlike the last time, we're working with broader coalitions like trucking, like real estate, like commercial, like large corporations and manufacturers across the state to really drive reform across the board. And again, education and outreach is really key to what we're doing, not just to physicians, but to your patients and to local community groups. On the judicial advocacy front, there's really two things that we do. One is amicus briefs, and that just means if you've got a case on appeal, MAG as an organization can come in and file a brief to try and persuade the appellate courts to rule in your favor. We have 3 that are pending right now. We have one specifically aimed at Nesselhut and wrongful death cases that says that because wrongful death didn't develop until well after the Georgia Constitution that guaranteed jury trial, that it didn't require a jury, and that capping damages in those cases would be constitutional in the state of Georgia. That would wipe out about 1/3 of the verdicts that we're facing on the nuclear side of the scale. That is supposed to come up before the Georgia Supreme Court this May, so hopefully at some point we'll have some positive news in this fight for you. The other thing that we've started looking at pretty closely is judicial elections. These are really important. They're going to happen this year in the state of Georgia on May 21st of this year during the general primaries. Every judge in the state of Georgia is elected, and they're elected in May. They are nonpartisan, but it's important to take a look locally in places at the judges, to meet them, to ask them questions, and to look at the appellate level where judges who make these decisions that impact medicine, how they rule and how you might want to vote. A lot of times this election is ignored. These are the 9 justices of the Georgia Supreme Court. Justice Colvin has actually been very favorable to medicine. Michael Boggs, one of our physicians, sits on his reelection campaign. This gentleman, Pinson, is up for election in May, and he has a contender. He might be the first incumbent justice in the history of the Georgia Supreme Court to be voted out. He got very unpopular because he was the lead reasoner behind this CVS case that you might have heard of. That was a nuclear verdict for almost $75 million against CVS pharmacies, where a Facebook marketplace transaction went wrong in their parking lot. They didn't even know it was there, and the gentleman was murdered. And they sued, and the lawyer said there wasn't enough security at your CVS. And CVS got hit with that verdict. So that made Pinson relatively unpopular. Again, none of these justices were on the Nesselhut court in 2010. They've all been appointed or elected since then, and they've shown that they are receptive to the concept of overturning that Nesselhut opinion and reinstating the non-economic damages caps. Very specifically, in this case, last year, Taylor versus the Devereaux Fund, they upheld the cap on punitive damages. And that was capped at $350,000, the same as non-economic damages. But the justices, particularly Colvin, were very critical of the Nesselhut opinion about whether or not it was, I mean, she came right out and said it. I'm unsure whether Nesselhut was correctly decided. Others question a lot of aspects of the ruling, which is why we are pretty hopeful about the arguments that are coming up in the next month before the Supreme Court. When we talk about legislative action, let's talk about a few of the successes we've had. Jeremy mentioned the Safe Haven bill. There's another really important tort reform measure that went through. This year was really sort of a trial year in the legislative session for our organization and a lot of other ones. It's the end of a 2-year cycle. The Georgia legislature works on a 2-year cycle. Any bills that didn't pass this year have to be brought again. They can't just go back to the committee they came from. They have to be brought anew. So we'll have a fresh cycle in 2025. and the governor who signed on his support to the tort reform effort. This was a governor's bill. What this bill was aimed at is collecting information on civil liability payments from insurers across the state since 2019 so that we can really get some in-depth data about where the pain points are when it comes to insurance and the costs that are being driven up and the types of settlements that are being done, so that we can carefully craft effective legislation and not just bring a slew of omnibus bills that are doomed to choke the legislature. Another one that was really interesting, we've had some successes in the past. Emergency physicians in emergency departments and obstetricians doing labor and delivery in the hospital setting are entitled to a gross negligence standard. That was expanded to healthcare professionals at inpatient facilities, particularly psychiatrists. So we've gotten just a little bit of relief and moved the needle for our 3 highest risk specialties. And that was a well-received bill. SB 73 dealt with attorney advertising. I mentioned earlier how much money was being spent in the state to attract new clients and build business for a handful of lawyers. That creates a requirement for the bar to set very specific limitations on the types of attorney advertising that can be placed out there, and creates a private right of action if you find attorneys violating this. It'll take a couple of months for this to become law, but it was a really interesting way to move the needle for not just healthcare, but all industries across the state. One bill that didn't pass that we learned a lot from was HB 1244, and that was really aimed at trying to just get third-party litigation funding reported in complex cases. And it met with a surprising amount of opposition from some unexpected places, and we saw just how effective the opposition can be at stymieing tort reform bills. But this is an issue that we'll be revisiting again. The governor is behind us. We've worked with the governor's office pretty directly on a lot of these issues and helped to craft some of the legislation we'll be seeing. And he will be termed out of office in 2026. I don't know what he's going to do, but between 25 and 26, as we look ahead to that session and beyond, we know that we're going to have a strong amount of support, all industries are, from the governor and his office to really build a large coalition to try and drive some real change across the state. A couple of the issues that we're evaluating when we look at these, the strategies that we're going to implement, one is phantom damages. I sort of mentioned that earlier. And phantom damages, when you bring a case before a jury, the evidence of damages are medical bills. And we know that what that bill says is not what's paid, but the jury awards the full amount of those bills. And the plaintiff's lawyers and the lien companies just split it behind the scenes. So we want to work on distracting that and talk about what was actually paid on behalf of this patient, as in terms of what the value of the case really is. Another initiative that we're examining is not caps on damages, but caps on contingency fees. That $1.5 billion, that's a $500 million that's going to go into the pockets of attorneys. Possibly more in the medical liability space. I've seen contingency fees as high as 45 to 48% on these cases. That's a lot of money. If we can disincentivize more frivolous claims from being brought because of the expenses involved here, that could go a long way to sort of tamping down the more frivolous aspects of what's going on in our judicial system. And again, third-party litigation funding. Another interesting initiative that a couple of legislators mentioned to us as we had discussions was trial bifurcation. And so what that means is there's really 2 things that a jury has to decide. One is liable. Was the physician liable? Did the physician fall below the standard of care? The second is, what were the damages that were experienced by the plaintiff? Now we see that generally all together. They take it all at once, which really clouds the issues. If we can just determine liability first and have a very objective conversation in the second half of the trial about damages, that should work to cool their outrage and to lower the amount of non-economic damages that they're experiencing. So that's one thing that we're looking very closely at. So our implementation, education and outreach, it's our message versus their money. When we look at what the opposition is spending, we're getting outspent about 15 to 1 down at the Capitol. But what we have is a message. What we have are our physicians across this state. And the legislators really listen to our physicians. And I have really been impressed at how much some physicians do. I saw one physician change an entire bill just on his own, reaching out to the legislators. And it's really important as a physician advocate to be comfortable reaching out. Your legislators want to hear from you. We only have 4 physician legislators, about another dozen or so that are involved in healthcare in some way or married to physicians. But out of about 260 legislators, a lot of them know very little about these issues. A lot of them don't have the training and education that you do, and they want to hear from you. Especially now in the off season, they want to hear what your problems are, what keeps you up at night, and how they can help solve this problem. So we have a few things as an organization that we'll do that we can do some more outreach on. We have a PAC, we have a tort relief task force. Jeremy mentioned we have task force. You can contribute. You can also serve on the task force. Again, coalition building and the grassroots effort. It really is important. In Atlanta, we can get 200 physicians to sign on to a letter trying to persuade a legislator, but that legislator, the legislators, there's 4 or 5 of them that those physicians live in their district. I can come to Augusta, or I can go to Dublin, or I can go down to Macon, and I can get 10 physicians to sign a letter to a legislator, and I can change one vote that way. It's really an important, powerful aspect of being a physician we oftentimes forget about because we're focused on our patients. So how does this impact you? What can you do? I mentioned physician advocacy. Participate with MAG at Physicians Day. We also have a Doctor of the Day program where we man a medical aid station. It's a great way to remain front of mind and keep our issues at the front of the minds of the legislators. Again, reaching out to your legislators is very important. Voting is very important. If you don't, you should. And volunteering your time or contributing to some of the efforts, whether it's with MAG or your specialty societies, whether it's your institutional providers, work with them. Understand what's going on and how you can help when you have a little bit of time. And sometimes it's as much as just sending a personalized email. You don't have to be Hemingway to get the attention of somebody in a position of power that will listen to your voice. Now, in your practice day to day, and this is what I want to leave you with, is there's a few things we can do now as physicians to really sort of tamp down on what's happening. And it's a little cheesy, but the first one is be brave. It's kind of a hard thing, but it warrants saying it. You're going to face medical liability claims, but don't let that intimidate you from the practice of medicine. And be brave in being willing to seek help. Take care of yourself. Be brave when it comes to examining what is offered by your medical liability carriers, your employers, your practices, and your organizations like MAG. We're all here to help you because it's a team approach, right? Physician-led care teams are the gold standard of healthcare. And it's not just your nurses, your mid-levels, it's not just all the clinicians that you work with, it's your hospital administrators, it's your employers, it's your outside organizations. We're all here to help and support you so that you can focus on delivering the best possible care on your training. And continuing education. Again, when we talk about training, when you're a physician, there's a lot of times that you have to make a life or death decision in about 10 seconds. And the reason you're able to make that decision is because you have all of the education. You have 4 years of undergrad, 4 years of med school, 3 to 5 years of residency, maybe a fellowship, right? Maybe years of practice experience. All of that knowledge, you have to continue ethically to promote and advance the practice of medicine and be better, to stay up on the latest procedures and understand. And if you make that decision in 10 to 12 seconds with your 12 to 16,000 hours of clinical training, it's important, right? Practice the best medicine that you can. And leverage technology, but don't let it be a crutch. I mentioned that we're going to probably see some dramatic changes with things like AI and certain types of procedures and medications that are being developed. But one note that I want to make is with electronic medical records. What I saw as a practicing attorney is that a lot of times you get into trouble with those. Don't let it be a crutch. I think far too often in trying to get done with charting, we rely on macros and cutting and pasting, but that can be a problem. Just to give you an example of a case when I was still a plaintiff's lawyer, had an impacted colon. And it was pretty nasty. The pictures were awful. The lady survived, it was fine. But when we got the medical records, we looked at them. And right there, alert and oriented times 3, bowel movement. It's like, there's no way that she was having a bowel movement. They were cutting and pasting, just trying to finish the charts, right? And that's a problem because your first line of defense is your chart. That's what is going to be used to evaluate the severity of the claim and your standard of care. So it's important to make an extra effort to use the technology, but just to understand that you chart, not defensively, but be honest, right? And learn about risk mitigation programs and strategies. Your employers, Augusta Health, WellStar, all of these places really have a lot of programs about when adverse outcomes happen, how you deal with the patients. Take some time to learn them. But also, I really encourage physicians to find out who their malpractice carriers are and go to the websites. The websites have tons of information about practice. They have free CMEs. I saw one insurer that had a complete mock trial that lasts about 30 minutes and explains the judicial process in and out. It really is helpful to help you understand what you might face and what impacts your practice on a day-to-day basis. And finally, just remember, yes, it's stressful. Yes, it's difficult. But the whole reason we're all here is for the patients, and it's patient-centered care. When adverse outcomes happen, your patients don't know. It's complex enough for all of us when we approach medicine. It's absolutely mind-boggling for them. And a lot of times when they're complaining, it's not a matter of fearing a lawsuit. It's about engaging and having empathy for your patient and delivering the best care you can. And that's really what you have to rely on. You're very well trained, you're very knowledgeable. Just the fact that you're here shows that you care. And so what you want to do is you just want to leverage that in your favor and practice the best medicine that you know how. Are there any questions? I know I've run a little behind.
Thank you, Brent. I know that we're a little bit over time, but I would love the opportunity for questions from the crowd because I'm sure that there are many. I think we can also field some of those online for the people that are participating online. So please feel free to enter those there. Any questions?
It's my contact information if anybody wants it. If you think of something and you can email me and I'll be happy to try and respond. Yes, sir.
We should support the public court judges and physicians to provide that information so that we'll know which ones are friendly.
We're working. Yes, sir. We're working on developing a list. We don't usually as an organization endorse politicians and things like that, but we are working on gathering information to educate our members about the histories of the candidates and the judges themselves. And our focus initially is on the appellate courts. We can work to find information about local elections. You feel free to email us. That's coming up pretty quick. So hopefully in the next 2 weeks, we'll have some information posted through our website and through our e-news and communications that'll give some insights into what's going on in these elections. Yes, sir.
The third-party litigation, third-party payer issue you talked about. How is this approached in the rest of the country? Is Georgia unusual in letting folks do this, or are most states putting restrictions on that?
Georgia is a little. So the question was, is Georgia unique in its approach to this third-party litigation funding issue? What are other states doing to curtail it? Other states have addressed this issue. About a third of them have passed laws to varying degrees of effect about disclosure of these things and regulation of these lenders. But Georgia really doesn't have anything on the books that affects this. So it's very poorly understood, if I'm being honest. So we're looking at how to craft legislation that will impact this. I think one of the most important things we can do is to get them to register and report so that we can see just how often these tools are being used within lawsuits across the state and driving up access to courts and driving down access to care. But right now, we don't have a law, but several other states do. Some prohibit it. I believe Florida passed in their tort reform package some regulations about these lenders. And one of probably the best things we can do is limit the amount of interest that they're able to charge or to change our banking and finance laws to present them as investments, because that's certainly what they look like on paper. Are there other questions? Well, thank you again.
Thank you very much to Jeremy and Brett for being here, and thank you to everyone for attending in person and online. In terms of housekeeping issues, first of all, let me also thank Cassandra Berard, who played a big role in pulling this together, and also to the staff of MAG and my staff in my office for helping to support pulling this together. Housekeeping issues in terms of CME. If you did not register, please make sure that you do. We'll be sending a link to your email to be able to claim CME. Is that correct, Jeremy? To be able to claim your CME for this event. And I would just encourage everyone, to our medical students that are online, as well as those that are here, to not let this discourage you. I certainly don't want to discourage people from practicing in Georgia, but we really do need to focus some efforts on making certain that our elected officials understand what is happening and how it impacts us and what the long-term effect of this will be if we don't make some changes. And that is a worsening of this position, the physician workforce in Georgia. So please make sure that you get engaged at the different events. The legislative session coming up 17 and 18 May. We'll also include that perhaps in the link that we send out, as well as the House of Delegates. If you're interested in participating in that, we will we'll distribute information on that as well. One last call for any questions. Thank you very much for being here, and thanks to our presenters.